All right, future barristers, listen up. If you are prepping for the Queensland bar exams, this is for you. Today, we are getting into client privilege. You need to think of this as your absolute best shield when it comes to disclosure. Seriously, getting this right is non-negotiable for protecting your client and, frankly, for building your career.
So let's cut right to the chase. This is the question at the heart of every single case you will ever run. What can you legally keep hidden from the other side? Get this right, and you're a hero. Get it wrong, and you could tank the entire case before you even get near a courtroom. So, where do we even begin?
The answer, your starting point for everything, begins with one rule you have to burn into your brain. UCPR Rule 212. I'm going to say it again. Rule 212. This is the gateway in the Uniform Civil Procedure Rules. It lists every single category of document that is exempt from disclosure.
Okay, so Rule 212 gives you this fantastic strategic toolkit. It's basically 4 essential shields. Let's break down each one, because you're going to need to master all of them for the exams.
First up is the Without Prejudice Shield. This is your go-to tool for protecting that really crucial and often pretty delicate dance of settlement negotiations.
The whole point of this is simple, but it's incredibly powerful. You know, the law actually wants people to settle their disputes. As the High Court explained way back in the landmark case of Field v. Commissioner for Railways, the way to do that is to create a kind of safe zone, a space where both sides can talk freely, even make admissions, without being terrified that those words will be thrown back in their face in court.
Now, here is a classic exam trap you really need to watch out for. You can't just slap the words "without prejudice" on a document and expect it to have some kind of magic protective power. It just doesn't work. The courts, in cases like Rogers v. Rogers, have been absolutely crystal clear. It's all about the substance, not the label. The only question the court will ask is this: was this a real, genuine attempt to settle?
In the case of Collins-Thompson v. Clayton is the perfect example of this. The court looked at a letter clearly marked without prejudice, but what was actually in it? It was just aggressive posturing. It made categorical claims, rejected offers. It wasn't a negotiation, it was a threat. The court saw right through it, and the privilege was lost. The shield was useless.
So let's nail this down. Here are your key takeaways. 1. The communication has to be a genuine attempt to compromise. 2. It protects all admissions, whether you say them out loud or just imply them. And 3, this is crucial from the case Glengallen Investments, a real defined dispute has to already be happening. No dispute, no privilege. It's as simple as that.
Let's move on to our second shield, public interest immunity. Now we're shifting gears. We're moving from protecting the parties in a case to protecting the state itself. It's a real balancing act between justice for one person and the interests of the entire country.
The big case here, the one that sets the foundation, is Sankey v. Whitlam, and it established a massive principle. This is not the government's privilege to just claim whenever it feels like it. It is the court's duty to decide. A judge has to weigh 2 competing public interests: the interest in getting justice in a particular case versus the public interest in preventing harm to the nation or the public service.
Now, the modern way to do this comes from Brookfield versus State of Queensland. It gives you a really clear 3-step test. Step 1. What's the potential harm to the public service if this gets out? Step 2. What's the competing public interest in making sure justice is done in this case? And Step 3. You balance them. Which one wins?
And here is the procedure that you absolutely need for your exams. If the other side claims this immunity, and you want to fight it, UCPR Rule 213 kicks in. Remember that, Rule 213. They have just 7 days to file and serve an affidavit spelling out exactly why they are making the claim. And for Crown claims, this isn't sworn by some junior public servant. It has to be a minister or the head of the department. That's how serious this is.
Okay, now for a fundamental right you're probably all familiar with, the privilege against self-incrimination. This shield protects a person from being forced to produce evidence that could be used to prosecute them, either in a criminal case or for a civil penalty.
And you have to understand, this privilege is interpreted very, very broadly. A document doesn't have to be a smoking gun confession. Thanks to the case of Rank Film, we know the shield applies if the document could simply set and train a process of inquiry that might lead to a penalty for your client. It protects against that very first link in a potential chain of incrimination.
Okay, this next point is a huge deal, a must-know. Memorize this case, EPA v. Caltex Refining Co. The High Court decided that this privilege is a human right, and because a company is not a human being, it is not available to corporations.
A company cannot refuse to produce a document because it might incriminate the company itself. It's a massive exception.
So how does this all work in practice? The case of Connolly and Harris v. McGrath gives us some really useful answers. For instance, a court can actually change a discovery order if the affidavit of documents would itself be incriminating. And remember that massive exception for corporations? Well, a company still has to disclose if there's an officer available who isn't personally at risk of incrimination and who can prepare the documents.
And that brings us to our final shield, parliamentary privilege. This one is unique. It's an absolute and ancient privilege that creates this zone of complete immunity around the core business of Parliament, and it shields it from any scrutiny by the courts.
The source for this power is incredible. It's Article 9 of the Bill of Rights from 1688. It's a cornerstone of our entire system of government. It basically ensures that members of Parliament can speak and debate freely without any fear of being sued or prosecuted for what they say or do while they're doing their job in Parliament.
Now, the key case of Rowley versus O'Chee shows you just how far this shield actually extends. The court held that the term proceedings in Parliament, which is defined in Section 16 of the Commonwealth's Act, is interpreted very broadly. It's not just speeches on the floor of the House. It includes the preparation for those proceedings, like a senator collecting documents for an upcoming debate. Those documents are protected. You can't force them to be produced in court.
And to bring it right back to your practice here in Queensland, the local provision you need to have at your fingertips is Section 8 of the Parliament of Queensland Act 2001. That's the statutory basis for this privilege in this state.
So there we are, our fourth and final shield. Mastering these 4 principles, all flowing from UCRP Rule 212, is absolutely 100% non-negotiable for success in your exams and, more importantly, in your practice.
And I'll leave you with a final thought to chew on. These principles, they were born in an age of ink and paper. So how is a court going to decide if a chaotic, emoji-filled Slack channel conversation is a genuine attempt to settle, or if a senator's saved memes are actually documents for the purposes of debate? That is the evolving challenge that you are going to face at the bar.